Hello 23,000 loyal followers. Today we're going to have a video about why petition for an alien relative may be denied. I decided to share with you my wisdom and about 15 years worth of immigration law experience in the United States and make your life easier by sharing this information. Maybe you are someone for whom such a petition was filed. Maybe you are someone who filed such a petition for your relative, for your spouse, for example. Or maybe you are someone who landed on this channel just to get some entertainment and learn how United States immigration law works. Welcome. My name is Alena Shautsova. I'm an immigration attorney from New York. And today we're going to talk about the most common denials, 4 of them, for one of the most commonly filed petition in the United States, petition I-130 for an alien relative. This is the document that you will be filing if you're seeking to sponsor your spouse, for example, for the United States green card or an immigrant visa. So thank you very much for joining me, and let's start. According to USCIS official statistics from July of 2021, about 220,000 of alien relative petitions were filed, and about 155,000 of them were for immediate relatives. Immediate relatives would be spouses of U.S. citizens, parents of the U.S. citizens, or children of the United States citizens. Children are those who are under 21 years old. Out of that number, let's say within the same period of time, about 17,000 or more or less 18% of petitions were denied. If you think about it, it's a huge number because about 20,000 people received denials instead of approvals, and hence their plans of uniting with their family members failed through. Why is it happening, and what can be done to avoid this? So let's talk about 4 most common reasons as to why an alien relative petition may be denied. And here I will focus mostly on marriage-based cases. Why? Because out of all the alien relative petitions, those are the hardest to win if we compare petitions that we file for our parents or children. Number 1, or the first reason, an alien relative petition may be denied if you fail to appear for the interview in connection with the I-130 petition, or you fail to answer requests for more evidence. Usually, of course, I call it a technical reason. I mean, unless you're somebody who just loves to waste their money by filing those hefty filing fees with USCIS and forgetting about your case, why would you intentionally miss your interview unless there is something more to it, or you would not answer that request for more evidence? Most likely what happens here is that either the marriage falls apart by the time you guys are called for the interview and you choose not to appear, or you miss the notice that asks you or directs you to appear. And that usually happens if you change your place of residence and do not update United States Immigration Services with your new address. Or maybe you tried to update them, but they did not update it in their system, which happens quite often. And as a result, you miss that interview, or you miss that request for more evidence that was mailed to you and you never received it. That's usually a technical reason. I would not worry much about that unless something else is going on, like your marriage is falling apart. And usually that particular reason for the denial can be cured with simple refiling. Second reason. If you filed a marriage-based case, sometimes it can be denied, not because you did not appear for your interview, or not because you do not have a real marriage with your spouse, but because you failed to prove that you were free to marry your spouse. Woo, how it happens? How? Why? Well, usually it happens because non-citizen actually mentioned that they were married at the time of the entry or at the time when they were filing for a visa to come to the United States, but they were not married. They were not married, hence they cannot show that they're divorced now. And during the USCIS process, the person naturally tells the truth that they were never married, but USCIS compares their answers on the forms with the answers they provided to that visa application questionnaire and determines that, wait a second, it seems that you are actually married. So now you have to prove that you divorced that spouse that you had in order for this marriage, the marriage that you are using to receive your green card or apply for your green card, to be accepted as a valid marriage. And here, usually a person will be stuck in a very unpleasant situation. Unless USCIS agrees to accept the fact that at the time of your visa application, you actually made a misrepresentation and allows you to file for a waiver, there will be no way to get out of this unpleasant situation. And a person de facto is considered to be married to two people at the same time. You will absolutely have to consult with an attorney if this is your situation, and hopefully it will never be your situation. Third reason that a petition may be denied, and here again we're talking about marriage-based cases. This is a big one. This is one of the most common reasons as to why your actual I-130 petition may be denied. It is for failure to prove that you have a real marriage and not the marriage that was entered into for the purposes of avoiding immigration law consequences. Or basically, fraudulent marriage to get the green card. That's the basic accusation. Marriage-based cases are very serious cases. Some people say, well, that's an easy way to get a green card. Of course, it's an easy way to get a green card if you have a real marriage and you can prove that. But if you are someone who is kind of laid back, you don't really worry about the paper trail of your relationship, or perhaps something else is going on, again, separation, tough marriage, you may face real tough time proving that your marriage is real. And if that happens, your marriage-based case will be denied, your green card will be denied, and I-130 will be denied. Usually it happens when, again, you either do not have sufficient documentary proof of your marriage, like joint bank statements, joint utility bills, lease showing that both of you are residing in the same place. Perhaps you are using two addresses for whatever purposes. Perhaps you are someone who actually leaves contradicting information about yourself in your social media. Perhaps you're someone who unfortunately failed a Stokes interview. Those will be the first bells to know that your I-130 case will be denied. How to address this particular issue? Well, if your marriage is real, you may choose usually two routes. You can appeal or you file your case. And the fourth reason as to why an I-130 petition may be denied. And this particular reason may be applied to both marriage-based and non-marriage-based cases. This is when the I-130 petition cannot be approved by law because the beneficiary of that petition is subject to 204C bar. It means that previously, in the history of that beneficiary, in the immigration history, there was a denial or there was an accusation or allegation by the United States Immigration Services that the person entered into a marriage and it was not real marriage. It was a marriage for immigration benefits only. Unfortunately, it can be applied years and decades later after such allegations were made against the person. Consider this. A parent, once when they were relatively new immigrant in the United States, entered into a fraudulent marriage tried to obtain their documents and failed, were caught by immigration, were denied the immigration benefits. Years later, decades later, this parent now has a US citizen son or daughter who are 21 years old and are willing to sponsor them. They're trying to file a petition I-130 only to find out that the petition is not going to be approved. And not because the parent and child cannot prove real relationship, but because any immigration petition for such a parent will never be approved because of that mistake that happened a long time ago. 204C bar. There are just very limited circumstances when you can overcome that 204C bar. For example, somebody who qualifies for a U visa and whose waiver in connection with that filing is approved may avoid the 204C bar. Perhaps there are some other circumstances when a person may overcome 204C bar, but they're very, very limited. In any case, when you were charged or you think that you may be charged with a 204C bar, you have to consult with an attorney. And here, last little tip, because you stayed with me till the end of this video. Interestingly enough, a withdrawn I-130 petition cannot be denied. Maybe some tiny tip will be helpful in your particular situation. So thank you very much for watching. If you like this video, please like, share, and join our channel so we can stay connected and meet each other again with more interesting information about the United States immigration laws.